The U.S. Supreme Court late Wednesday night refused to block a Texas law that amounts to a ban on abortions after 6 weeks of pregnancy. The vote was 5-4, with 3 Trump-appointed justices joining 2 other conservative justices. Dissenting were conservative Chief Justice John Roberts and the court's 3 liberal justices. The decision left open the option for abortion providers to challenge the Texas law in other ways in the future, meaning the case possibly, or even likely, will return to the Supreme Court, though not for months or longer. The opinion was unsigned. It said the abortion providers didn't properly address complex and novel antecedent procedural questions in their case. In reaching this conclusion, we stress that we do not purport to resolve definitively any jurisdictional or substantive claim in the applicant's lawsuit, the decision said. In particular, this order is not based on any conclusion about the constitutionality of Texas's law, and in no way limits other procedurally proper challenges to the Texas law, including in Texas state courts. The ban on abortions after cardiac activity can be detected, usually at 6 weeks of pregnancy, and well before most women even know they are pregnant, is at odds with the Supreme Court's precedents, which prohibit states from banning abortions prior to fetal viability, usually between 22 and 24 weeks. The Texas bill, however, was stricter to insulate the law from being tested quickly in court. Because the established procedure for challenging a state law is to sue officials charged with enforcement, the Texas state legislature wrote the law instead to put citizens in charge of enforcement. Specifically, the law allows anyone, without establishing any vested personal interest, to sue clinics and individuals alike for aiding and abetting abortions performed after about 6 weeks. That potentially puts in the crosshairs of liability not just clinics, but individuals who staff the clinics, who drive patients to clinics, or who help finance abortions.